Good afternoon, everybody. My name is Jeff Lerman, and welcome to what every multifamily and residential landlord must know, all who have come through the speakers instead of my database, and I want to welcome all of you. I am the real estate investors lawyer, and I am also a real estate investor. We focus on helping investors, whether you own apartments or any other commercial real estate, or actually any real estate at all, with their transactions and litigation. From the transactional standpoint, everything from entity formation to asset protection, joint ventures, syndications, purchase and sale agreements, loan documents, construction agreements, commercial leases, virtually everything in the cycle of ownership, and any disputes that arise from those transactions. This is a topic which I am particularly interested because in our office building, which I hope at some point I get to meet each of you in our offices for good reason, we happen to have apartments. Those are the second story of our building is 6 apartments, and we own other apartments throughout the country. So this is a topic which I have a particular interest in. So a couple disclaimers here. On this call, you're going to hear 2 lawyers and a broker speak, and it is important for you to understand what disclaimers apply, but I don't want to get lost in the legalese, so let me summarize it for you. We are not your lawyer, you are not our client, and you can't sue us. What I mean by that is that you're going to hear a number of legal topics discussed during the next hour. And what you hear is just the beginning of your education on this topic. Do not take any action based solely upon what you hear during this webinar. If there's something that you are interested in, I encourage you to reach out to the speaker who you heard it from, contact them and ask them to follow up or whatever. But these professionals that you will meet during the next hour are experts in their field, and that's why they're on this call. So that is how you can use this webinar. The agenda for this call is we're going to begin with McLaughlin, the lawyer, and then we'll speak with Helen Chong, who is a broker, and then we'll do Q&A. So as far as Q&A, if you have a question, you should see a place on your screen where you can ask the question, type it in, and I'll be looking at those throughout the event, and we'll get in as many questions as possible at the end of this event. And of course, if you have to leave early, you'll all get a recording of this event after the event is completed, so you'll be able to hear anything that you may have missed because you didn't stay for the whole event. So to begin with, we're going to start with Mr. McLaughlin, and let me introduce you to Michael. Michael is a founding partner of McLaughlin Sanchez, based out of San Francisco, and he specializes in rent control and evictions protection and represents landlords only. Michael has been practicing law for 20 years and is a member of the California, New York, District of Columbia, and Maryland bars. Michael, I did not realize that you were a member of that many different bars. Michael, are you on the call?
I am on the call.
How did you took 4 different bar exams?
Well, actually, it's called the DC 2-step. So I took the Maryland bar initially 20 years ago, and then because I scored high enough, I was able to waive into the District of Columbia. And after you're a good member of good standing in the District of Columbia for 5 years, you can waive into New York without taking New York. But then I had to sit and take the California bar. So I'm a member of 4 bars, but only took 2.
Wow, that's crazy. And Michael regularly appears on behalf of landlord clients in both the Superior Court and before the San Francisco and Oakland rent. I think that should say bars. And also, I've known Michael now for, I don't know, a couple years, and we cross-refer clients all the time because Michael and I do different things. Michael, as I just explained, he does exclusively rent control and evictions protection. So whenever I have a client and I have an issue that involves any of those, I refer those to Michael, and he shoots over his referrals to me of people who that he encounters who needs in terms of need help in transactions or litigation. So it's been a great pleasure to work with you, Michael. Michael is my go-to guy, and he's the expert in these areas, and that's why he's on this call. So, Michael, with all that put aside, I'm going to turn it over to you and let you give your talk.
All right, that sounds great. Thanks, Jeff. So let me start off by saying that the new state statute, rent control and eviction protection in the state of California, follows the two-part structure of local rent control ordinances that you'll find in places like Berkeley and Oakland, San Francisco, Santa Monica, West Hollywood. All of these local rent control ordinances have two basic components. The first are what I call price controls. Those are rent controls. They control the amount of rent that a landlord can raise, the amount that the landlord can raise the rent in any given year. And then they always have what are known as the just cause for eviction protections. And the two components of these rent control statutes, including the statewide statute that we're going to be talking about today, they work in tandem. You have the price controls, and then the just cause for eviction protections exist largely to protect the tenant's enjoyment of the price controls. Because otherwise, if you had price controls without eviction protections, you could simply terminate the tenancy and get the unit vacant and re-rent it out without any price control. So there are the two components at the state level and also at the local level. So Jeff, if we could go to the next slide. Let's talk first about the price controls that exist under the new state rent control statute. And very broadly speaking, the landlords are limited in the amount that they can raise a tenant's rent to 5% plus the local CPI, the consumer price index for your local area, or 10%, whichever is lower. So what you do here is you say, how much can I raise the rent on my tenant? You take 5%, then you go to the Bureau of Labor Statistics and you get your inflation index for your local area. Here it's the San Francisco, San Jose, local area there. Add 5% plus the local CPI for the year. If it's more than 10%, you can only raise it by 10%. If it's less than 10%, you can only raise it by the lower amount. Okay, that's relatively straightforward. You can only do 2 increases per year. Now, why anybody would want to stagger, an 8% rent increases in 2 tranches over the year is beyond me, but the statute allows for it. Most of the local rent control ordinances allow you only to raise the rent once a year, but this new state statute allows you to do it twice a year. And then the state statute preserves the concept that exists under California law that we lawyers that practice in this area call vacancy decontrol. What that means is that, let's say you've got a long-term tenant in there and they're paying a rent-controlled price. As soon as that unit comes back to you, the landlord owner, vacant, no one's in it, and you're going to go and rent it out on the open market again, you are not limited to what the prior tenant was paying. You can go out and get the market rent for it. So let's say I had a tenant in there for 10 years and they were paying, way under market. The tenant finally left. I got the unit back vacant. Now I'm going to re-rent it out again. I don't have to re-rent it out at the price controlled price that the 10-year tenant was paying. I can set it, the initial rent, at any amount that I want going forward. So that's what vacancy decontrol means. And it's a very, very important concept under these rent control statutes. Okay, so big picture, I don't want to spend too much time on some of the there are some exemptions that I didn't put down here, like things that are not likely to be of interest to the people on this call, like dormitories and hospitals and things like that. But the big exemptions that people are really interested in are the first big exemption from the price controls are single family homes and condominiums. What the statute actually says is they say those are rental units where the title to the property is separately alienable to the title to any other property. It generally means single family homes and condominiums, where the owner is not a real estate trust as defined by the Internal Revenue Code section 856, a corporation, or an LLC where one member of the LLC is a corporation. And also, to be exempt when you have a single family home or condominium, you have to give notice to the tenant that the unit is not subject to the price controls. For between now and July 1st of 2020, you've got to give that notice to the tenant outside of the lease. But starting on July 1st of 2020, the notice to the tenant has to be within the lease in order to enjoy the exemption from rent control. Okay, so what does that mean as a practical matter? Let's say I've got a single family home and I own it as, I just own it in trust or as in my individual capacity. So I satisfy subsection A there. If I want to raise the rent and not be subject to the price controls, before I do the rent increase, I've got to send a notice to my tenant informing them, hey, by the way, this property is not subject to the price controls. And then I can send my rent increase notice. For leases that I enter into after July 1st, 2020, I've got to make sure it's written in the lease. Or if it's not, I can amend the lease by serving an amendment to the lease, which is a 30-day notice. And then thereafter, it'll be part of the lease, and then I can do my rent increase. So it's just a little bit cumbersome. If you've got a property that you think will qualify for this exemption, I would definitely consult with a lawyer before you start imposing rent increases, just to drill down on that. The next big exemption are duplexes, where the owner lives in one of the units at the outset of the tenancy and continues to reside there. So it would not include a duplex where you were not living in one of the units and you wanted to increase let's say you had a 2-unit building, unit 1 and unit 2. The tenant lives in unit 2 and you move into unit 1, but the tenant lived in unit 2 before you moved in, you would not be exempt. So you got to be living in there at the outset of the tenancy and continually reside there. The next exemption under the state statute is housing built in the last 15 years. So if it's 2019 now and going on to 2020, that's going to be property that was built in 2004 and going 2004 to 2019 here. But you'll see that this is a different exemption that exists under the local rent control statutes that exist. So for example, in San Francisco, all properties built June 13th and prior are subject to the rent ordinance, and those that are built after are not. But what's going to happen in the state statute is since it's just in the last 15 years, you'll have properties that were at one time exempt from the rent controls, but as time goes on, they will fall subject to the price controls. So, for example, right now, properties that were built in 2004 would be exempt, but as of next year, those properties will be subject to the price controls because it'll be 2020 minus 15 is 2005. So you can see more and more housing is going to fall subject to the price controls as time goes on. All right, Jeff, we can go to the next slide.
2 quick points. So you mentioned here something that needs to be going to the lease. For those of you who are used to using form leases, which makes a lot of sense in California, I don't know yet what, if any, amendments are going to be made in the leases when this goes into effect on January, but I strongly recommend that you talk to an attorney. You can talk to us, or if you have another lawyer that you use for your leases, and make sure that you understand what, if any, new language you want to include in your leases that you write after January. And also, to the extent this talks about single-family homes and condos where the owner is not a trust or LLC, where one member is also a corporation. If you have any questions about that and LLCs and asset protection, that's something that we can help you with as well. Okay, yeah. Michael. Continue.
Going back to that, just one other clarification, Jeff, if we could go back to that slide for just a second. One thing I want to just alert everyone to, let's say you have a lease that was entered into on July 1st, 2020, and you entered into this lease and thereafter said, oh shoot, I forgot to put in that provision. It's not that you're going to be forever subject to the price controls. We can do an amendment. We have to serve proper notice, but we can change that lease to include the disclosure language. So you might lose a month or two of the exemption, but you would not be forever barred if you do make that mistake. That mistake can be fixed by amendment.
Great.
Okay, so the effective date of the price controls is January 1st, 2020. But it's retroactive to March 15th, 2019. And here's essentially what the law says, is that if you did a rent increase between March 15th, 2019 and December 31st, 2019, you're gonna have to go back and figure out what the rent was on March 15th, 2019, and then reset the rent for the tenant as if the price controls were in effect on March 15th, 2019. So 5% plus the local CPI, okay? But what the law says is that you won't have to disgorge or pay back any rent overpayments that the tenant may have paid. You'll just have to go back and set the rent at the allowable amount for March 15th. All right. Jeff, I think we can go to the next slide. All right, so that's the basics of the price controls. Now let's talk about the just cause for eviction provisions of the statute. This statute follows most of the local rent ordinances in that it has two broad kinds of just cause. There are just cause, what we lawyers call at-fault just cause, where the tenant did something affirmatively wrong that justified the landlord terminating the tenancy. And then there are those classes of just cause where the tenant didn't do anything wrong affirmatively, but the landlord nevertheless can terminate the tenancy and get possession back. The first bullet point here says that for those units subject to the statute, you've got to state one of these just causes in the notice terminating tenancy. What do I mean by that? Let me be clear on this. In the past, prior to the passage of this statute, if I wanted to terminate a tenancy, a month-to-month tenancy, I simply served either a 30-day or a 60-day notice, and I just said, dear tenant, I don't want to rent to you anymore. As of 60 days from service of this notice, your tenancy is terminated. I didn't have to tell you why. In fact, I didn't have to even have a reason. I could just decide I didn't want to do it. The only thing I couldn't do is I couldn't discriminate against you or retaliate against you. So long as I wasn't doing that, I didn't have to tell you why I didn't want to continue renting to you in the future. Now, I have to state one of the identifiable just causes for eviction in the notice itself and be ready to prove that cause should the tenant refuse to leave and I have to evict you and we go to trial. All right, Jeff, next slide.
By the way, Michael, are you okay if people would like to get a copy of these slides, if I can share these slides with everybody after this webinar so they don't have to worry about taking notes on everything?
Oh, of course, yeah. Yeah, and it's
Okay.
got my contact information on it as well.
Great, so for all of you, you will get a handout with all these slides, so don't worry about taking notes.
Okay, so the first class of just causes that would allow a landlord to terminate the tenancy, the first big one is the non-payment of rent. If you don't pay the rent, you can get a 3-day notice to pay rent or quit. So non-payment of rent. The next one is a breach of the lease. The tenant is breaching some covenant in the lease. It's an interesting wrinkle here in the statewide rent control and eviction protection statute here is that you have to first, under this statute, give the tenant a 3-day notice to correct the breach and then follow up by a notice of termination. So under the local rent control statutes, I can just serve a 3-day notice to perform covenant or quit. It's a little different under state law. I got to first send you a notice to correct it, and then I can serve a notice of termination. The notice of termination under the state law that I serve you after the notice to correct does not have to give you an additional time to correct the breach. So it's a little wrinkle right there. If you get into a situation like this, I highly recommend that you consult with a lawyer. The next just cause is nuisance. This is where the tenant is doing something that disturbs either other tenants in the building or the landlord's quiet enjoyment of the property. The next just cause is waste. Waste is, it's a legal term. I think of waste, the best way to describe waste is if you take a sledgehammer and hit and start banging on the drywall in your unit, you're committing waste. The next just cause is the extension of lease. So under this statute, and this is also a just cause at the local level as well, if I have a 1-year lease and I, a landlord, want to extend your lease for another 1-year period, and the tenant says, no, I want to go month to month, but the landlord wants to extend it for another term, and the tenant refuses, that's a just cause to terminate the tenancy. The next just cause is criminal activity, selling drugs, etc. Unapproved subletting. So if you have a prohibition in your lease that prohibits subleasing without the prior written consent of the landlord, and almost all leases do, I won't say all of them do, but most of them, especially the form leases that Jeff was talking about, they'll have a prohibition on subleasing without the prior written consent. That is a just cause under the state statute, which is going to be a little bit different than the San Francisco statute. The San Francisco statute, that this as a grounds for eviction has really been pared back to it's almost impossible to evict a tenant in San Francisco for subleasing in violation of a covenant in the lease. But it does exist under state law. Refusing lawful access. This is when I want, there's a statute, a civil code section that allows the landlord to enter the property for necessary repairs, to exhibit it to purchasers, and so forth. If you refuse lawful access to the landlord under state law, it's a just cause for eviction. The next bullet point here is illegal use. You may be thinking, well, how is that different from criminal activity? Here's how it's different, and we lawyers that practice in this area think of this differently. Criminal activity can be, you know, any activity that's a crime. It could be prostitution, it could be drug activity, etc. Illegal use, I usually think of this one as it usually involves a violation of some building code or housing code. For example, I've got 10 people living in a 1-bedroom apartment that in violation of the housing code. That's an illegal use. If you've got that situation going on, that's a for-cause grounds for terminating the tenancy. The next bullet point is, and this bullet point's important, it preserves the ability to terminate a tenancy, and I put tenancy in air quotes because if you have a licensee, you're not a tenant. But this is when you've got somebody, let's say grandma allows her grandson to live with her and he doesn't charge her rent, doesn't charge him anything, he just lives there with permission, and that permission can be revoked. If you revoke that permission with somebody who's sharing a house with somebody and they won't leave, that's a just cause to get them out. The last one's a super powerful weapon. This does not actually exist under the San Francisco rent ordinance. So this, I'm really glad to see that this was preserved in state law. And that is, if a tenant offers, it says, it gives you notice. They write to you and say, hey, listen, I'm giving you my 30-day notice. I'm going to be out on November 1st. The landlord, the most important thing a landlord wants to do in that situation is to write back and tell the tenant, I accept your surrender. If you do that and November 1st comes and goes and the tenant has not left, that is a just cause to terminate the tenancy under state law. That's in the Code of Civil Procedure. I mean, yeah, the Code of Civil Procedure as well, but that is not a just cause for eviction under the Oakland and San Francisco statutes. So it's really good to see this under state law. Okay, so now let's flip over to the no-fault just causes. The no-fault just causes are the first really big one is the owner move-in, which we lawyers in this area call the OMI. And that is, under state law, it can be the owner or the spouse, domestic partner, a child, a grandchild, a parent, or a grandparent. And either the tenant has agreed to allow the eviction to go forward, which I can never imagine happening, or the lease allows for it. So you've got to, for those leases entered into after July 1st, 2020. So you've got to make sure your lease allows for an owner move-in eviction, or if your lease doesn't, if you enter into a lease after July 1st and you don't have that provision, you can amend the lease like you could in the other situation and include that provision. Here's one thing I'll say about this is a very, very powerful weapon for landlords to get possession back where the tenant didn't do anything wrong. If you have the honest intent to move back into your property and live in there, you can do that. What's really interesting here is that this provision under state law follows the Oakland statute and is much more generous than the San Francisco statute. In the San Francisco statute, if you want to move a child or a grandparent or a parent into the property, you have to also be living in one of the other units on the property in order to do that kind of relative move-in eviction under San Francisco law, not under Oakland and not under state law. So this is a more generous provision than exists under San Francisco. The next one is the Ellis Act. This is the state statute that allows you to take a rental property entirely off the market. You can't selectively use the Ellis against 1 or 2 units. If you're going to Ellis Act a building, you have to take all of the units off the rental market. The next provision for no fault just cause is if you get a government order, if you get a citation, let's say the city of Oakland comes in and says that you've got some problem relating to habitability and it requires the tenant to leave, or you get a government order requiring that the tenants vacate, a red tag. I've got a situation like this going over in Oakland where some people are living, for example, in a commercial space, and the government comes in and says, you can't live here, it's not zoned for residential, you got to get out. Or a local ordinance requires vacating the unit. Those are just causes to evict. The last one is the substantial remodel or demolition. What's really interesting, so this is where you're going to go in and do something that's not cosmetic, like painting and decorating, but you're actually going to substantially remodel the unit. What does that mean? What constitutes a substantial remodel? Yeah, the statute actually tells us that, Jeff. So let me pull it out. Substantial remodel, and I'll just read it so that everybody can kind of hear what this is. Substantial remodel means the replacement or substantial modification of any structural, electrical, plumbing, or mechanical system that requires a permit from a government agency, or the abatement of hazardous materials, including lead-based paint, mold, or asbestos, in accordance with applicable federal, state, and local laws, that cannot be reasonably accomplished in a safe manner with the tenant in place, and that requires the tenant to vacate the residential real property for at least 30 days. So essentially, if you're going to do something that requires a permit and the work to some plumbing, electrical, mechanical system, or to abate lead and mold and things like that, and you cannot safely do this work with the tenant in possession. You can, and it's going to require them to be out for more than 30 days, then you can terminate the tenancy to do that. Let me say this on that point. This is if Jeff, we could jump back to that slide for just a second. This is where I know this statute is just the beginning, because under the local rent control jurisdictions, when you do an eviction like this, you have to offer, once you're done with the work, you've got to offer the tenant the right to reoccupy that unit at the rent control price. That does not exist under state law. So this right here, I know that the legislature is going to come and clamp down on that, because this is just a big gaping hole where landlords are just going to say, okay, well, I'll just do a substantial remodel and I'm going to terminate these tenancies. There's nothing in state law that says you got to offer that back to the tenant at the rent control price, at least not now. So that's going to be a really, really big gaping hole. I think this is a bullet point that quote unquote will be subject to abuse. All right. The next piece, when you're doing a no fault eviction, this is true in the local statutes as well, you've got to give the tenant relocation monies, right? And relocation is equal to 1 month's rent or a 1 month rent waiver for no fault evictions. You've got to notify the tenant in writing of their right to relocation monies for the no fault evictions. All right, Jen. Okay, so here are the properties that are exempt from the just cause for eviction provisions. There are a few others, but these are the big ones, everyone. The first one is housing where the landlord and tenant share a bath and kitchen facilities, This is also an exemption from proving just cause in the local ordinances. If you live with your tenant, you share the bath and the kitchen, and the landlord and the tenant live together, the landlord can terminate that tenancy without having to state a just cause. The next one is the single family owner occupied residence where the landlord does not rent more than 2 units or bedrooms. And that would include like a mother-in-law or an ADU. This is a substantial expansion of the exemptions from just cause that exist under the local rent control jurisdictions. In the local rent control, under the local statutes, you usually have to be living with, the landlord has to be living with the tenant and rent no more than 1 other bedroom. And it does not include where you've got somebody in an in-law. So this is substantially more liberal than the local jurisdictions. Okay, the next property that's exempt from just cause are duplexes where the owner lives in 1 unit and had resided there at the inception of the tenancy. Buildings built within the last 15 years, but just as under the price controls, as time goes by, more and more properties that had been exempt from the just cause provisions will fall subject to them. The next properties that are exempt from just cause are just very similar to the ones for the price controls, single family homes and condominiums where the owner is not a real estate investment trust, corporation, or an LLC where a member of the LLC is another corporation. Duplexes where the owner lives in 1 of the units at the outset. And also, you're not subject to, and this is an important last point here, you're not subject to the state ordinance if you are subject to a local just cause ordinance. So for example, those properties that were built and had a certificate of occupancy issued before June 13th, 1979 are subject to the San Francisco rent ordinance. They will remain subject to the San Francisco rent ordinance and not the local state ordinance. But, and here's the real rub, those properties that had a certificate of occupancy issued on June 14th, 1979, all the way up to 2004 in San Francisco, they used to be exempt from just cause and rent controls, but now they're subject to the state one because they're not subject to the local rent control ordinance, but so they used to enjoy exemption totally. Now they're subject to the state. So we've got a real patchwork in San Francisco. We've got those properties built before June 13th, 1979, subject to the local rent control ordinance. Those properties built between June 14th, 1979 and 2004, which are subject to the state law, and those properties that are built after 2004 and to today, which are exempt. So we've got a real patchwork in places like San Francisco. Okay. Just like in the rent, we've got to provide the tenant notice of the property's exempt status. And for those tenancies after July 1st, 2020, that notice must be provided in the lease. I think that's it, Jeff.
Okay, great. So we do have so far a number of questions, and if any of you have additional questions, keep on typing them in your screen, and I will get to them after we hear from our next speaker. Helen, you're with us, correct?
Hi, Jeff. Yes, I am here.
Great. Okay. So Helen is she is a certified commercial investment member. And Helen, tell the audience what CCIM exactly a CCIM is all about.
Sure. So the CCIM. Yep. So CCIM stands for Certified Commercial Investment Member. And so you have to take a few quite intensive courses, really focusing on financial analysis and how to analyze properties. Only 6% of the commercial real estate professionals actually have this destination. So it makes it quite, it's not something that you just take one day of class and you can get this destination. You actually have to have a portfolio requirement as well before you can achieve this. And most people will tell you that after they get this destination, it's just such a big relief and such a big accomplishment because it does take a number of years before you can get it.
And it's nice that you're going to be the new president of the NorCal chapter of CCIM starting January 1, right?
Yes, that's correct. And it's definitely very exciting. Thank you so much.
Yeah. and you're also founder, CEO of HAYLEN Group. You handle residential and multifamily. You are a broker, board of director for the last couple of years at the Santa Clara County Association of Realtors, 15 years in the real estate industry. You speak at a lot of functions on this topic and others involving multifamily. Author, what book have you written?
So actually, I'm in the process of writing. It's probably going to be published early next year, and it's probably kind of a book that is more about my life story and how and why I decided to step into real estate, and really a book to inspire a lot of immigrant women, mothers, or anyone who just want to feel like they need to take control of their life. And real estate is a way that I'm demonstrating on my book how you can do that.
Great. Okay, well, welcome to the webinar. And so talk to us a little bit about what you have seen so far in terms of reactions from real estate investors.
So the reactions is interesting because I was just speaking at a real estate expo. Obviously, I met with a lot of real estate investors, and some of the investors, they might be more experienced and some are just started. And 90% of the investors I spoke to, they all mentioned the statewide rent control right away. And they all immediately leaning more towards investing in another state instead where there's no rent control. So psychologically, I think a lot of people, as soon as they hear the word rent control, they just try to run away, because no matter if they really understand every single aspect of it, but it's just something that it really discouraged them to step into it, because they feel like there's going to be a lot more restrictions. It's probably not a place where they can make more money. And so that's why I do see that there's an impact to the psychological impact to the real estate investors in California.
Well, I'm not surprised. As an investor, as an apartment investor myself, I have always avoided going into cities where there is rent control, just because it gets more complicated and you don't know what you don't know, and you can inadvertently violate a law that you know, even though you certainly didn't intend to, and that does make it more complicated. So not a big surprise there. So what do you think this will do in terms of impacting the values of anybody who has an apartment building in California, not just an apartment building, but any kind of a residential rental property? Well,
as you know, a lot of investors, or I should say property owners, if they have owned the property for a long time, we've seen this over and over again, is that they charge way below market rent. And then when they sell it, most of the times, real estate brokers will help them use a pro forma analysis, right, to see what kind of market rent they can get in the future. And so a lot of times investors are buying those properties based on the pro forma numbers. And that's why it's been quite expensive. Now, if you are a property owner who haven't been raising rents in the past years, and you're trying to maximize the property value, it's probably going to have some impact, and quite a bit of impact on your value. And unfortunately, this kind of a reminder to a lot of landlords is that they really should continuously to raise rents at least at a moderate level, so that their market value of the property maintain as high as possible. I think this is going to have a lot of impact with properties, especially if their market rents, if their rents have been way below market rents.
And tell me, do you think, I understand that Governor Newsom's thought when he approved this was that this would have some impact on the housing shortage and the housing situation in California. What thoughts do you have in terms of whether this new law will solve the housing inventory issue?
So I think we were talking about housing inventory issue is mainly because they worry that the housing price is also getting way too expensive in California. So that's why, and which caused by the housing inventory issue. Now, the pricing wise is obviously a supply demand. Everybody understand that. And so to solve the pricing, we need to increase supply by doing the rent control and also a lot of regulations now on the new construction. As we all know, first of all, new construction developers are getting slapped by these huge fees, like impact fees, and all these development fees sometimes can be as much as $150,000 additional fee per unit. And that is not going to encourage people to build, for sure. And then now on top of that, rent control law is coming into place. A lot of times, again, developers using pro forma numbers, trying to see like what will be the future value of their property is going to be. And by having these rent control will definitely, again, will reduce the future market value of the property. And that's why, honestly, I don't think this rent control law is going to help with the new construction. It's not going to help with the supply. And unfortunately, it might continue to impact the pricing.
Right. So bottom line, do you think this new rent control law should discourage buyers from buying a residential property in California? Well,
actually, for the buyer's situation, I don't think they should be discouraged because like what I just mentioned, right? The value of those properties a lot of times is going to be a decrease. As a matter of fact, for sellers, unfortunately, the value is going to, they cannot pricing as aggressively. So that means the pricing of these apartment building is going to be more reasonable. And as a buyer or as a buyer's agent, when we do analysis for our clients, even though let's say back then before this rent control law was implemented, even if you can raise rents by 10, 20%, most of the time, our clients don't plan on increase rents that much anyways, unless it is a tenant that they don't even want. They want to keep the property occupied as much as possible. So when we do our analysis, we are still doing a pretty reasonable analysis based on about maybe 7%, 8% increase. So now we have this rent control law. It does allow 5% plus the CPI. That can still range around 7, 8%. And then if you use that kind of approach to calculate and to do our 10-year analysis, for example, you'll see that it is still in California, it is still one of the most safest, the most stable market to invest in apartment building. I think for buyers, they need to really focus on that. Investing in California is for a stable, safe, and long-term growth here.
Okay.
Hey,
Stay with us on this call.
This is a little out of my area, but I have just a comment on that. In a way to juxtapose the local,
sure.
like say, let's take the San Francisco ordinance and juxtapose it to what the rent caps are in state law. Under the local San Francisco ordinance, for example, you're capped at 60% of the local CPI. So you're like half the rate of inflation in San Francisco under the San Francisco ordinance. But as Helen was just saying, statewide, you're getting 5% plus the regional CPI, which could be, 8 or 9%. So even the rent controls statewide are much more generous than they are in the old, local rent ordinances.
Great point. Great point. Okay, stay with us. We've got questions, and I'm just going to go through these, and let's see if we can give these people some answers. First question, what about a condo that was converted in 2007 where the building was built in 1925?
Yeah, those are, at least under the local rent control jurisdictions, those are subject to the rent caps. Even if the condo conversion happened after the effective date, if it was used for residential purposes prior to that, you're going to be subject to the rent and just cause for eviction provisions.
Okay. And Gary asks, in Oakland, if the owner lives in the triplex that, in the triplex then is exempt, will this no longer be the case? I guess he meant to say that is exempt.
I understand the question. That triplex exemption from the local or Oakland rent ordinance was eliminated, I think like 6 months ago or so. So that's no longer the law in Oakland. It used to be, if you had a 3-unit building and the owner lived in one of the units, you did not have to state a just cause to terminate the tenancy of a tenant in one of the other units, but that's gone away. That's no longer the law in Oakland.
Okay, but he also has a follow-up question, which still generally applies. Does this new law override the city law or the local law? And I guess your answer is
no. It does not. It does not preempt a local. It does not preempt a local rent and eviction control statute. So if you're subject to, say, the Oakland or San Francisco ordinance, you are not also going to be subject to the state law.
Okay. And Gary also asked, will Section 8 still be exempt?
Yes, there are exemptions in here for rents that are controlled by government agencies.
We have a number of people actually who asked a variation of that. The question is to which law ultimately preempts, and so you're saying regardless of which specific law we're talking about, the local law is going to supersede or take precedence over the new state law, correct?
Yeah, that's correct. So long as the local statute offers the equal or greater protections, and all of the existing ones do, than the state law, then the local ordinance is going to apply.
Okay. Grace asks, if the owner wants to sell the property for whatever the reason, under the rent control law, can the owner sell or not?
You can always sell with a tenant in possession. The question usually is, can I terminate a tenancy so that I can sell the building vacant and that which is more attractive? The answer is no. That's not a just cause for eviction. It's not under the local ordinances, and it's not under the state law.
Okay. Let's see. I'm seeing if there's any other questions that haven't already been asked. I own 8 single-family homes that are in a family trust. Am I exempt?
If you're those types of properties are not the kinds of trusts that are exempted out. Those are very specifically real estate investment trusts as defined by the Internal Revenue Code. So if you have properties that are in a family trust and you otherwise meet the exemption, you should still be exempt.
Okay. And I see a question here from Nelson. Nelson, if you're still listening, your question is a little bit too specific. I would encourage you to contact Michael if you want to discuss your question with him. Those are, I believe, all the questions that we have. So for anybody who, I think here are the main takeaways. For anybody who owns a building that is not exempt, or even if you're not sure if it's exempt, you need to talk to Michael. You now have a building that is going to be subject to rent control starting January 1 of 2020, and you really don't know what you don't know, and this is something that is really important. You're talking about these properties are worth a lot of money, and what you don't need is to inadvertently violate one of these rent control laws. Any parting comments, Michael?
Yeah, I think I would just amplify that as far as 2 points. One is, if you want to know whether you have a property that falls within one of the exemptions, you really need to chat with a lawyer about that. And 2, if you ever get into a situation where you want to terminate a tenancy, it is my belief, having practiced for a number of years in this area, is that you must have a lawyer in California to do this. It's just simply not possible to legally terminate a tenancy that is subject to a rent and eviction controls without having a lawyer who practices in the area. I've never once seen it happen. You have to have a lawyer, and preferably one that specializes in this area.
2 more questions just came in. One is, if a tenant is under a month-to-month lease, can I evictify him selling the property?
No, that's not a just cause.
Okay. So but under month-to-month, so since month-to-month has no longer term, at the end of a particular month, if they want to terminate the lease, can they do that, or
that's an
or
excellent
not?
question. That's a really excellent question. Here's the answer. The answer is no. You're required to continue accepting monthly rent checks until you can serve a notice terminating that tenancy that states one of the just causes. And that's a substantial change from the way the world used to be. It used to be that if you had a month-to-month tenancy, and let's say the tenant had been there for 2 years, I would simply serve them with a 60-day notice terminating that tenancy without having to state any reason at all. So long as I wasn't discriminating or retaliating against the tenant, I can just simply stop renting to you. But that's no longer the case. That's the real effect of a just cause for eviction provision, is I can no longer terminate that month-to-month tenancy without stating and proving one of the recognized just causes.
Another question came in. John asked, do I need to notify all my tenants that I am exempt, and what time frame before the lease is up?
Yes. So if you have existing leases now, I would notify your tenants, and you can find the notification that you have to give them in the new Civil Code section. I'll give you that Civil Code section right now. It's new Civil Code section 1946.2 for the just cause provisions, and you'll find the language of the notice that you need to give there, and the notice you need to give if you're exempt from the price controls can be now found in new Civil Code section 1947.12.
Okay. Another question. After all original tenants move out, I can still put the unit back up to market, correct?
That's correct. That is what we call. There are a couple of questions embedded there. And let me address both of them. The first one is, let's say that you had A, B, and C go on a lease, and all A, B, and C leave, and they turn the unit back to the landlord vacant. That's what we call vacancy decontrol. So I can go out into the market and re-rent that at whatever initial rental rate that I want. The next question is a really, really interesting one. Let's say A, B, and C enter into a lease, and as the years go by, A leaves, B leaves, and C leaves, replaced by D, E, and F. The question is, let's say A left first, B left second, C remained, and then C left. So all the original occupants no longer live there, and they're replaced by the people who came in, their subtenants D, E, and F. Under Costa-Hawkins, you can raise the rent to market on D, E, and F when C leaves, when the last of the original occupants no longer permanently resides there. That is Costa-Hawkins. That has not been abrogated by this law. So that's still the law in California. So the answer is yes.
Okay. Another question, can you have a 6-month lease indicating that a tenant has to leave in 6 months?
Excellent question. The answer is no. Any attempt to waive or otherwise bypass the requirement of stating a just cause is against public policy and it's not enforceable.
Okay, that may be it. Okay, very good. That does it. Everybody, I appreciate your attending, and Michael, appreciate you sharing your expertise with us, and Helen, thank you very much for giving us the perspective from the owner's standpoint on what this impact will be for the multifamily and the 1 to 4 unit residential options. So thank you all, and we will be in touch with you when we have a new report to discuss with you. Thank you very much.
Thank you so much. Bye-bye.
Bye-bye.
Bye-bye.